Good morning from Caithness in the Scottish Highlands. This is Anne-Marie from Charmed Life Therapy. So, it's time for a little catch up. I kind of have not been doing much for a couple of days on Baldoni because obviously the Perez Hilton thing was going on, and there wasn't a big reveal as such. So kind of I didn't really feel the need to add to it from what other people were doing. Sometimes I just sit back and see if there's room for me to have a different perspective or whatever, because rather than just spout the same things to you. So sometimes I don't always comment on it. So from what I understand just briefly of what's going on with Perez, it would seem that he has to gather some quotes now for a digital forensic expert to go through his files. And Blake Lively will have to pay for one of those quotes. And from what I understand, they will gather that information. But I imagine it'll be like Baldoni in that they have to first agree search terms and things like that. So I think that could all be what adds to the length of time it takes. And I think that's what Perez is kind of feeling like. You could be talking the best part of another year for this all to be ongoing if she proceeds with it. And I'm not altogether sure she will proceed with the Perez issue, but basically, yeah, all that information would be gathered based on search terms that would have to be agreed, I would think. And then a privilege log will be compiled from that as to what privilege applies, whether it be attorney-client or whether it be journalistic. There'll be a little snapshot beside to refer to each document, and that privilege log and the documents will go to the judge, and he will say whether it is privileged or not in any sense, and whether she gets to have them or whether it's relevant to her case. So all of that could take a very long time. And I think, as Perez himself admits now, he probably is going to need a lawyer. And I don't fault him for asking for it pro bono either, although clearly he probably will have money. But as many people that show up on social media and people make assumptions about them, it doesn't necessarily mean you're cash wealthy or that you've got a lot of money to give away. So I can fully understand why he would ask for somebody to help him pro bono. And I do think that's kind of like what we said before about this case. We of us that are all invested in it think everybody knows about it automatically. And it's still surprising how many people really don't. And I do think there are lawyers out there who would help Perez or who would have helped the content creators, but the message really wasn't getting out beyond our little bubble. So I do think there will be somebody that comes forward and helps him, because I do think there are good lawyers out there who want to do this type of pro bono work, who would see the dangers inherent in journalistic free speech being brought into question. So yeah, so that's ongoing in the Perez saga. And like I say, I'm not overly convinced that she will proceed with it. I think kind of what we're seeing now from her lawyers, who are all obviously highly educated and experienced, but the things they're having to say on behalf of this client and the types of arguments they're having to compose, I think it just shows you more and more. Apparently this Merrill, who was one of Blake's lawyers in this argument with Perez, apparently she was really quite thrown in the courtroom and a bit flustered. And I think it is because she's having to fight this argument that Blake Lively's right to have the information is more important than Perez Hilton's journalistic freedoms, which is quite a big egoistic statement, isn't it, for a lawyer to have to put out there, my client's rights to get to the truth of what is being done to her is more important than the First Amendment. It's quite a big, as a lawyer, you're probably groaning internally, aren't you? With the best will in the world, you're probably thinking, what have I got myself involved in? So even people that are highly experienced, and they clearly are, Blake's lawyers, it's not going well for them, is it? Because if they're having to do it based off of what she's insisting, which is the problem when you're dealing with people that either are narcissists or have narcissistic tendencies and won't listen, you're forced into this position of just doing what they say if you're being paid by them, and it will often not make sense. But yeah, so let's move on to what was really fun last night. It was time for a little pick me up, and it certainly cheered me up. I kind of opened it up not overly expecting too much, and within like a couple of lines, I was like, "Oh my God, this is so much fun." If legal documents could be fun, last night this certainly was, and I was having a few little chuckles. It couldn't be helped. So what I want to do first is just share this image. So let's bring him up. So this, if you can see him, this gentleman here, who looks rather like a kindly grandfather, somebody you trust with your children, and all the rest of it. He looks like safe pair of hands and all the rest of it. Wouldn't have a cheeky little comeback or necessarily. This apparently is it is Charles L. Babcock, who is one of Jed's attorneys. And this is the guy that I believe has composed this filing last night. And so this is the guy that also got to depose Blake. And I think what this filing tells us is that this guy is not really worried about Blake Lively. From whatever he's seen in person and her responses to questions, I think he feels like he can make these kinds of filings with nothing to worry about. And I think you've got to think he's spoken to Blake in person and he's questioned her, and he is hoping to bring her to Texas to fight Jed Wallace's suit there. So he's clearly seen things that aren't leaving him very worried when you read these filings. And this is the guy that brought up the question, what article is it specifically that my client has been responsible for or authored, or you believe that he has seeded or generated or manipulated or whatever? And Blake could not point to one specific article that bothered her. So this is the guy that was there in the room. And I think I don't know what I was expecting when I went looking for the picture. I think I was thinking more along the lines of a Kevin Fritz younger dude. And when this guy's face popped up, I thought, this is so much fun, given what he's written. I think, oh gosh, yeah, he's either discovered this for himself or he's got canny people working for him. But this has been filed under his name, so he's quite clearly happy with it. So yeah, I find this rather interesting. So let's kind of bring up the information. So if I close that down, because we don't need that one there anymore. Screen sharing has stopped. Okay, so let's share the next one, which is, this is the actual, no, it's that one I want. Okay. So this is the document itself. So if I pop that up there so I can see. So this is the reply memorandum of law in support of defendant's motion to dismiss or alternately sever and transfer. So it's addressing Blake's response to their motion to either get rid of him out of that New York jurisdiction entirely or move it to Texas, where everything else is being dealt with, basically. So I'll try and whiz through it. I don't necessarily need to read all of it, but I mean, it captures you. It has to be said right from the first sentence. Like the seasons, Blake Lively's efforts to retain jurisdiction over Jed Wallace and street relations are ever-changing, from a conspiracy-based theory of jurisdiction asserted in the spring but rejected in the summer, to now in the fall a novel theory that Lively had not raised in her prior complaint, but which is now the primary focus of her argument, specifically that Section 302A1 of the New York Long-Arm Statute confers jurisdiction. And this is what we said all along. It's been like this from the start when it came to the forum shopping, the Van Zandt of it all, where you just fake something in order to get something from somewhere where you shouldn't have it. We're seeing it all through it, this cherry picking. If this isn't working, I'll need to do a bit of that. If nobody's believing SH, I have to do defamation. If defamation isn't working, I have to do retaliation. And I have to keep pivoting. At first, it was all Jed Wallace and Wayfarer themselves. Then suddenly it's Brian Freeman. Then suddenly it's Brian Freeman's investigative firm on his behalf. It's ever switching. It's Perez Hilton. Perez Hilton is the sole focus. So Perez Hilton is the one subpoena that we really truly have to go through after investigating 107 other ones, apparently. Somehow Perez Hilton is the most specific one. It keeps changing, changing, changing. And in that one paragraph, you get a nice little snapshot of that. So you imagine this is that cheeky little grandpa looking person that's doing this sort of mild snark, which is quite amusing, I think, really. So this change is likely explained by Lively's inability to overcome her pleadings and sworn testimony that the two, so sworn testimony, it's like deposition, isn't it? That the two claims against the Wallace defendants sound in defamation. So kind of this keeps popping up, and my brain works in such a way that I'll remember it once what that meant, and I won't remember it again the next time it comes around. So it's basically, when it's sound in defamation, it's basically saying she's making all these arguments that she's not calling defamation, because if she calls it defamation, then certain things that in law that she doesn't want to apply will apply to it. Because the long arm statute has restrictions on defamation, I believe, something to that effect. We'll go it'll probably become clearer as we go more through it. But basically, it's saying she's alleging all these things that she's not calling defamation, specifically related to this jurisdictional element, but they add up to defamation. Basically, that's what it's saying. So, and thus the conspiracy theory of jurisdiction found in section 302, A2 and A3 is inapplicable. So her 2-paragraph attempt in a 31-page brief to overcome the defamation exception is hardly a response at all. The colours in autumn are so bright just before they lose it all. And I thought, as soon as I read that, and I'm patting myself on the back because I think I might have been among, if not the first, among the first to spot that line, because I opened it up when it must have come through straight away last night. I thought, that's really familiar. I did a quick Google search of that line, and it was, as suspected, it is a Taylor Swift song. So it's like From Red, and I think that's what's the smart thing about it, because it's not. It's like, did they think of that? Did they think of the changing seasons argument first, and then go looking for a Taylor Swift thing? And they do know, it's well known that I think Taylor's favorite season, or certainly a season she's written a lot about, is fall, isn't it? Is autumn. So it's like, which came first, the chicken or the egg? Did they think of the line first and then base the seasons argument around it, or was it the other way around? But it's kind of clever that it was kind of slightly lesser known Taylor song, slightly less obvious quote. I think that's what's kind of genius about it. And who is it more tailored to except us, and directly at Blake Lively, really? It's like a jab to the heart, is that one, really, isn't it? And that's that cheeky grandfather looking person doing it, or having it, or somebody getting that on his behalf. So the change of seasons has not cured the novelty or inapplicability of her argument. So the defamation exception forecloses jurisdiction under these parts of 302. A defamation claim is defined in terms of damage to reputation. Thus, New York law considers claims sounding in tort to be defamation claims. So what that basically means, tort is just another word for civil wrong. So where those claims seek damages for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect on her reputation, these are precisely the claims Lively alleges here. So she basically saying she can call it all the things she wants, but they believe it falls under this defamation. What did they call it? It's gone out of my head. Begins with E. Exception, the defamation exception to this long arm statute. Specifically, Lively's claims against the Wallace defendants are founded on her assertion that they engaged in a retaliation campaign that created, seeded, manipulated, and advanced disparaging content. This alleged campaign, Lively asserts, caused devastation to her reputation. Further, Lively specifically alleges in her false light and FEHA claims that the Wallace defendants, hopefully you can see that a bit better now, participated in a campaign to discredit and bury her reputationally. And the more and more you hear this, and we saw it in one of the Perez filings the other day, how it talked of the Wayfarer defendants bragging about doing these things to her, as if, and it was like really hard to read because it was like, you're just putting words in people's mouths here. You're completely twisting it from what is just evidence of written things without the context around them to saying this gang of people was sat around a table or something, just having a good old party about what they were going to do to this woman, which is something completely different entirely, isn't it? And publicly made false and misleading disclosures that harmed her reputation. So even Lively's general allegations regarding the actions of unspecified defendants show that she seeks to redress alleged reputational harm caused by false statements. Lively refuses to substantively engage in this argument, ignores her own allegations, and instead relies entirely on her ipsy dixit. So I went on to Google again. Dogmatic and unproven statement is an ipsy dixit. That neither the false light claim nor the FEHA aiding and abetting claim fall under the defamation exception. So I believe this is Federal Employment, is it Housing Act or Association, something like that. But it's to do with that. It's who you go to for employment related things anyway. It's probably administration, something like that. Anyway. So 715 at 17, Lively also appears to argue that the exception does not apply to her FEHA claim because it is based not only on the Wallace defendants' boosting of negative narratives, but also on their provision of advice and counsel to the Wayfarer parties. Yeah, you see, that's another way it flipped, isn't it? She suddenly started calling him the mastermind as if he was in charge of things and he was directing things. He went from being an employee to being a mastermind, didn't he? Activity, she asserts, does not arguably sound in defamation. Lively misses the point. It is the reputational injury she seeks to redress through her FEHA claim that matters, not the precise manner in which the Wallace defendants are alleged to have aided any retaliation campaign. Don't think there was much there in this footnote. Not anything that we don't already know anyway. I think I didn't bother highlighting it for that reason. Okay. Because Lively's claims against the Wallace defendants indisputably sound in defamation, she cannot predicate jurisdiction on 302A2 or A3. Right, so the first part of that. So through an agent language does not permit a conspiracy-based theory of jurisdiction. Under 302A1, a non-domiciliary may be subject to personal jurisdiction if he transacts any business in New York, either in person or through an agent. Lively contends that the phrase through an agent permits the court to exercise jurisdiction over a non-domiciliary, like the Wallace defendants, through the acts of a co-conspirator. While this may be true, in the 302A2 context, where tortious acts by a co-conspirator are a well-recognized basis for personal jurisdiction, it is not the case when, as here, 302A1 is invoked. So this court, so whatever is quoted there, this court rejected Lively's very argument, i.e. that a co-conspirator's allegedly tortious acts in New York can establish a basis for personal jurisdiction under 302A1. Instead, this court reiterated that that requires an agency relationship in which the purported agent acted purposely in New York for the defendant's benefit and with the defendant's knowledge. Thus, Lively's conspiracy-based theory of jurisdiction based on that through an agent language fails. And there's just more case law cited up here, I think, basically. I don't think we need to look at that. So Lively does not and cannot establish the agency relationship contemplated under 302A1. So 302A2 contemplates a specific agency relationship where the agent is an in-state actor who operates at the behest of a non-domiciliary principal. Thus, for 302 jurisdiction to exist over the Wallace defendants, the co-conspirators must have acted in New York as agents under the control of the Wallace defendants as their principal. Lively, however, alleges the inverse, that the Wallace defendants are the agents of the co-conspirators. Indeed, Lively alleges that the co-conspirators hired the Wallace defendants and also controlled the Wallace defendants' activities, courts have declined to find jurisdiction where, as here, the non-dom defendant acted as the agent of the domiciliary. So, see Sachs, blah, blah, blah. Jurisdiction did not exist where the non-domiciliary defendant acted at the behest of the alleged in-state co-conspirator. So Lively's claims do not arise from the transaction of business in New York. Lively does not allege that the Wallace defendants transacted business in New York in person. Additionally, the absence of the requisite agency relationship prevents the in-state co-conspirators' alleged business transactions from being attributed to the Wallace defendants. And there's case law cited there. So it's just specifying here the language, that she can't suddenly turn it to him being a mastermind of it all when she was previously saying retained him, engaged him, tag engaged, tag retained. Miss Abel and Miss Nathan directed. Miss Abel was calling for Mr. Wallace to take action. It's like getting clear on that, basically. So this case law cited here, absent facts establishing the requisite agency relationship, the transacted business element could not be plausibly alleged. Then, but even if attribution were possible, none of the co-conspirators actually transacted business in New York. Transacting business means that a party purposefully avails itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws. The only transaction Lively specifically points to is the co-conspirators' trip to New York on August 4th to 6th to promote the film, consisting of press appearances and attendance at the film's premiere. But alleged co-conspirators' mere attendance at press events and a premiere, activities that rise at most to the solicitation of business, do not constitute transacting business under 302A1. And don't forget, Jed Wallace wasn't there. So, case law quoted there, mere solicitation of business within the state does not constitute the transaction of business within the state. It's talking about attendance at a trade show in New York did not constitute transacting business, even though the visit might ultimately work to the defendant's pecuniary advantage. So even if attendance at these few events constituted transacting business, Lively's claims against the Wallace defendants do not arise out of these transactions, i.e. there is no articulable nexus or a substantial relationship between the claims asserted and the actions that occurred in New York. Lively does not allege that the co-conspirators engaged in any wrongful conduct during these events and fails to even discuss this nexus requirement in her briefing. The only thing I'm not sure about there is the Steve Sarowitz thing, because she did allege that he said certain things that she found threatening, or or that statement about Israel and such, wasn't it, where it was going to be like Hamas and all of that. I don't know how this little paragraph here deals with the fact that didn't she supposedly allege that. That's my own bit of confusion there. So whatever case law that is there, it says jurisdiction failed where plaintiff failed to articulate how his claim arose from a promotional event in New York. So in fact, Lively admits that there is no nexus between any New York transactions and a FEHA claim, admitting that her retaliation and aiding and abetting claim is premised on California-based conduct, admitting that a significant part of the retaliatory scheme was all carried out by California-based persons in California. For this additional independent reason, Lively cannot predicate jurisdiction on 30201. A1. Lively's conspiracy-based theory of jurisdiction under 302A2 fails. So even if the defamation exception did not plainly apply, which it does, Lively fails to allege facts supporting a conspiracy-based theory under 302A2. To establish the Wallace defendants' membership in a conspiracy for the purposes of New York's long-arm statute, Lively must allege specific facts showing the Wallace defendants had an awareness of the effects in New York of their activity. The activity of the co-conspirators in New York was to the benefit of the Wallace defendants. And 3, The co-conspirators acting in New York acted at the direction or under the control or at the request of or on behalf of the Wallace defendants. So they had to be in charge, which is the inverse, isn't it, as we just said. So the Wallace defendants explain at length in their motion why Lively still fails to make this showing, including that she does not allege facts showing that the Wallace defendants were aware of overt acts in New York. Lively attempts to show otherwise by pointing to email timestamps, area codes, and Instagram posts. But Lively never alleges that Wallace saw these timestamps or area codes, much less that he understood them to mean anyone was presently in New York. This is also the case with the Instagram posts. Lively attempts to connect the Wallace defendants to these posts by boldly alleging that anyone engaged in passive observation of the social media environment would have been aware of these posts. So it's that thing, isn't it? That I'm so important. Everybody's watching everything and putting a lot of thought into it. So this is not a reasonable inference, but rather pure speculation that fails to satisfy Lively's burden to allege specific facts warranting the inference that the out-of-state defendant, not simply anyone, had an awareness of the effects of its activity in New York. So there's more case law there. Mere speculation is insufficient to withstand a motion to dismiss. Lastly, Lively argues that because the Wallace defendants do not argue they have ever removed themselves from the conspiracy, their alleged involvement in the creation of a website in 2025 somehow constitutes a substantial overt act in New York. First, the Wallace defendants averred is the word there. I had to go Google that one. So averred is state or assert to be the case. I'm learning so many words through this. I thought I knew some big words, but it's teaching me a whole lot of new ones. It's so funny when these weird new words start popping up in your vocabulary because you've simply been hearing them for so long at this point. And like half the time when I'm using them, I don't know if I've used that in the right context, but it sounds good. First, the Wallace defendants averred, so stated or asserted to be the case, that they were not involved in any conspiracy, meaning there was no conspiracy to remove themselves from. Even if the Wallace defendants were involved in creating the website, Lively admits that it only contained materials filed in a prior lawsuit and thus is not actionable. So statements made in the course of litigation are entitled to absolute privilege. And even if the website were actionable, there are no allegations that this website or those responsible for its publication had any connection to New York sufficient to trigger 302A2. Case law quoted there, where jurisdiction based on website, where there was no allegation that defendants published the website in New York. And another piece of case law there, website did not confer jurisdiction under 302A2, where there were no allegations that it was created in New York or maintained on New York servers. Yeah, the little thingy here, nor does Lively address the Wallace defendants' arguments concerning the expansiveness of the Eastern time zone or the portability of cell phone numbers. You know, like that was the argument when they're saying you can't tell from a cell phone number where somebody is because people, hang on to the numbers and they move state to state and all the rest of it. You can't guarantee where somebody is just based on a phone number. So jurisdiction under 302A3 fails. To satisfy 302A3, Lively had to allege facts showing the defendant's tortious act was committed outside New York. The cause of action arose from that act. The tortious act caused an injury to a person or property in New York. The defendant expected or should reasonably have expected that his or her action would have consequences in New York, and the defendant derives substantial revenue from interstate or international commerce. For the reasons discussed above and in the motion, Lively has not alleged any facts from which this court can reasonably infer that the Wallace defendants expected or should have reasonably expected that any act they undertook would have New York consequences. Lively continues to point to the $90,000 the Wallace defendants received from the alleged co-conspirators, but this only shows what the Wallace defendants earned from a single engagement, without comparing that amount to the revenue the Wallace defendants derived from in-state, i.e. Texas-based business. So case law cited there where the upshot was where out-of-state corporation derived 4% of its revenue from New York, i.e. $400,000, 302A3's substantial revenue requirement was not satisfied. Absent this necessary context, Lively has not alleged facts established that the Wallace defendants derived substantial revenue from interstate commerce, so due process is not satisfied. As explained, there are no factual allegations supporting the reasonable inference that the Wallace defendants were aware of the alleged co-conspirators' presence in New York, or that they took any act in furtherance of an alleged conspiracy while in New York. On the contrary, the facts alleged show that the Wallace defendants were blindsided by the alleged co-conspirators' contacts with New York. Thus, because a defendant cannot reasonably anticipate being hailed? Should it be hailed or hauled into a court as a result of contracts that are unknown to him? The exercise of jurisdiction over the Wallace defendants would not comport with the due process clause. So Lively fails to state a claim against the Wallace defendants. Lively does not address the most significant relationship test or meaningfully contest that under that test, lots of tests, either New York or Texas has the most significant relationship to Lively's claims against the Wallace defendants. She's doing her best to ignore Texas and what's going on there altogether. Nor does she dispute that the laws of those jurisdictions bar her false light claim. Contrary to Lively's contentions that California law does not require her to plead the elements of the defamation claim in connection with her false light claim, that is what federal courts analysing California false light claims have required. The mere fact that Lively has not alleged a defamation claim against the Wallace defendants does not excuse her from pleading the elements of a defamation claim in connection with her false light claim. So I think there's lots that overlap, isn't there? I nearly said allegedly, between false light and defamation. And for the reasons dismissed in the motion, Lively failed to plead those elements. Is there anything there? I don't think I need to read that. So Lively's admission that FEHA does not apply to non-residents employed outside the state when the tortious conduct did not occur in California is fatal. So here Lively alleges no tortious conduct that occurred in California and instead plainly predicates her claims against the Wallace defendants on purported New York-based overt acts. Additionally, even assuming the actions of Lively's employer were discriminatory, there are no allegations that the Wallace defendants knew that conduct was discriminatory or for the purposes of retaliation or harassment. I guess there's nothing in writing that says we need you to do this because we need to retaliate against her or harass her or discriminate against her or anything like that. So thus Lively fails to adequately plead an FEHA claim because Lively's false light and FEHA claims are fatally infirm. So too is her civil conspiracy claim. We note that Lively has not... Sorry, it gets fun. We note that Lively has retreated not only from her primary conspiracy-based jurisdictional theories, although she puts up a game front, but despite repeating verbatim large swathes of her second amended complaint, nowhere mentioned is the previously pleaded winky-faced emoji. I went back and tried to find the winky-faced emoji, but for some reason I can't find I can find the document, but it's like as if I've not got access to it again, and I seem to have deleted it out of my folder. But I believe that's where Jamie, that was exchanging messages. Was it with Jed? I think it was with Jed. And Jamie used a winky-faced emoji. And they kind of, then this Wallace's team said, well, it can't have possibly been New York related then, because the sheer presence of the winky-faced emoji would tell any, self-respecting New Yorker that conduct, that message, that connection, whatever it was, took place in California because of the winky-faced emoji and California's reliance on excessive use of winky-faced emojis, basically. But it's like you didn't address our point that the winky-faced emoji was critical. And it's really, really clever because is it also alluding to the fact of that missing emoji back years ago on the text messages that added so much context, the exclusion of the sarcastic emoji kind of, like when they were saying, oh, aren't we so great at this like stuff kind of thing, blah, 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 and put a sarcasm emoji on it. But then that didn't turn up in the edited text, did it, that Blake presented as part of the CRD. So is this bit of fun these lot are having with the winky faced emoji and what that means a subtle throwback dig to that as well? It's quite funny, isn't it? And it's a funny thing to be bringing up in a court of law in a semi-respectful way, that you didn't address the winky faced emoji argument we presented. So nor has she clarified the post, which Lively claims the Wallace defendants must have seen and understood. So this post depicts Lively under the caption, Blake Lively at Blue Jean Baby, NY Lady, which anyone who has listened to Elton John or watched the movie or seen the play Almost Famous knows is not NY Lady, but LA Lady, the address Lively used when she sued Wallace in Texas. We would concede that the Blue Jean Lady, wherever found, was in fact a seamstress for the band, but with all that, the motion to dismiss should be granted. So that's Tiny Dancer lyrics that Blake used in her post, but amended to suit New York. And these have pulled it back to actually that was LA Lady, and wherever she was in fact a seamstress for the band. But I think you just kind of needed that last night, or I did, because it's so easy to get bogged down in this case and get lost in the unfairness of it all, that you do keep needing these little jabs of humour. And I think their side is very much aware of this, isn't there? That Hudson and co are not faring well because they're bringing no humour to it, no levity to it. It's all arguments and victimhood, and this was done to me, and I feel this way about this thing, and it doesn't matter if I have evidence to back it up. I feel this way about this thing, so it has to be right. It's kind of their argument. But yeah, I had a lot of fun with that. So what I'm going to do is just quickly look, because I fed that into Chat GPT and just asked, I always ask it to kind of, what are the key points here, basically. I don't rely on Chat GPT for like necessarily everything, but it kind of gives you a little bit of a perspective on it. So I'll just bring up my Chat GPT notes, and it might just clarify a few bits or remind me of something that I was going to share and I've forgotten all about, basically. So which one is it? It's this one. So let's share that. So let me just move that oops. Let me just move this so I can see it again. So zoom in my way. So the core issue, can I blow it up a bit? Is it going to go up? Yeah. So Blake Lively is trying to keep Jed Wallace, PR fixer, according to ChatGPT, and street relations in the lawsuit in New York. Wallace is trying to get out, saying, this court doesn't have jurisdiction over me. Even if it did, the claims are legally defective. And I keep having to remind ChatGPT that I am Team Baldoni, because it keeps trying to drag it back to, to being Team Blake Lively, so I don't know who's paying ChatGPT. So too, the sound in defamation argument. What does sound in defamation mean? It means that even if Blake doesn't call it defamation, which is basically libel or slander, her claims are really about damage to her reputation. So courts look at the essence of the claim, not just the label. If it's about hurt reputation from false statements, it sounds in defamation. So why this matters? New York's long-arm statute, the law that decides when out-of-state people can be sued there, has special rules that exclude defamation claims from certain jurisdiction hooks. If Blake's claims against Wallace are really defamation in disguise, she can't use New York's long-arm statute to drag him into the Southern District of New York. Wallace points out, Blake's own complaint says the retaliation campaign involved false, disparaging content that caused devastation to her reputation, but she can't specify which piece of it. Even her false light and FEHA aiding and abetting claims say Wallace helped bury her reputationally. Translation, this is defamation dressed up as other torts. So Blake's shifting jurisdiction theories. Wallace says Blake keeps changing her legal theory. In spring, a conspiracy theory of jurisdiction. Under that, court didn't buy it. Summer, switched to a novel theory using 302A1, business transactions in New York instead. In the fall, now, she doubles down on 302A1 as above. Wallace is clapped back. You can't just rebrand your case every season when the last argument fails. But as I said at the beginning, that's what we're seeing over and over and over again, isn't it? That she just keeps changing it. She's so invested in her own narrative, in her own story. She's so lost to it at this point that she has to keep pivoting in order to hang on to it because she's desperately looking for a way to make it fit. And it's that I find really quite sad. I think that there's not going to be any point, no matter how intense this gets, where you actually say, am I actually wrong here? And that does tend to lead you to thinking, well, is she delusional? Either as an official condition as part of her makeup, or whether like a chosen delusion, whatever you might want to call it. So why Wallace says NY jurisdiction doesn't work, so the through an agent theory fails. Blake argues that Wallace can be sued in NY because his co-conspirators acted there. But under NY law, that only works if the co-conspirator is your agent. So that means acting under your control. So maybe the Steve Sarowitz thing and whatever he may or may not have said in New York, maybe just something he said doesn't count for anything of this. It's not like an action that was taken. It was just a comment he made. Maybe that's why it's not like an official cause of action, if you like, that happened in New York that was to do with some kind of co-conspirator thing. It was just a literal comment that he made. Maybe that's how that's explained. But Blake's own complaint says the opposite, that Wallace was hired and directed by people in New York, like PR execs and Wayfarer staff. That makes him the agent, not the principal. Wrong direction equal no jurisdiction. So she's kind of claimed both things, as we said, both that he was a mastermind and yet acting on behalf of other people. And you can't really be both, can you? 302A2, A3, conspiracy theory fails. Blake claims Wallace knew about New York acts like the post, the area codes, the timestamps. Wallace says that's speculative. She never pleads he actually saw or knew those were New York based. The courts would say speculation equals not enough. Attending a premiere in New York, transacting business. Blake points to the premiere in New York City. Wallace states attending press events isn't business transactions under the statute. So attacks on the substance of Blake's claims. Even if jurisdiction were fine, Wallace says Blake's claim should still be tossed. So the false light claim, under both New York and Texas law, the states that matter for him, you have to meet the same standards as defamation. Blake hasn't. So the California claim, the FEHA claim, FEHA doesn't apply to non-Californians acting outside California. Blake admits the alleged Wallace conduct was New York-based, so that's fatal to that argument. Civil conspiracy claim. If the underlying claims fail, conspiracy fails too, because you can't have a conspiracy about something that didn't happen or that you didn't take part of or weren't aware of. So 6, the term. Wallace's lawyers sprinkle in sass, comparing Blake's shifting arguments to the seasons changing, quoting Elton John's Tiny Dancer to mock her use of NY lady versus LA lady. See, even ChatGPT didn't notice it were Taylor Swift lyrics, basically saying her theories are crumbling and she's clutching at straws. And I think that's what the Taylor lyric tells you as well, isn't it? The colours in autumn so bright just before they lose it all. And it's like, oh, lose it all. And that's kind of where the kind grandpa element comes in. I think it's kind of saying, lady, are you willing to lose it all? This is where it's heading. This is where you're going. Your arguments are falling by the wayside. If she loses Jed out of this, which I feel I mean, I think it'd be pretty shocking at this point in time if Jed Wallace doesn't get himself dismissed out of this jurisdiction, or at least have it severed and transferred. What is she left with? She's literally only really left with accusations against Brian Friedman and who he might have employed to take investigative actions on Wayfarer's behalf, all of which is normal process. She's basically left with the subpoenas that are still being fought over. Obviously, there may be still some that we don't know about that are still in the process and we haven't got information, but basically talking about Andy from Popcorn Planets is still in play, isn't it? And Perez's is still in play. There's probably others, like I say, that are having these little mini fights all over the country or whatever. But it's not enough to base a case on, is it? I mean, she's basically, I think, just got one quote from Melissa Nathan where it implies that information was given to Perez, but it's probably just in the form of a statement that went out to many other people. It's like how Andy from Popcorn Planet got a statement from Brian Friedman, but the same statement went to other people too. It was literally just a press statement. And Perez has got his arguments to say, actually, these people really had no respect for me. They really only wanted to use me when it seemed my content was getting some traction and I might be useful. So that doesn't imply he's being paid or being gifts or being gifted things in order to produce content against Blake Lively. So I think it is looking, very perilous for Blake, in my honest opinion, my non-legalese opinion. So 7 mistakes. If Wallace wins this motion, he's out of the New York case completely. That weakens Blake's smear campaign story because he's the guy she paints as the PR hitman. Without him, it's harder to tie Wayfarer to a coordinated online attack. Again, it's that thing of, isn't it? How can there be a conspiracy if the person conducting the things that the conspiracy theory put into play, if he's not a factor of it anymore, doesn't the conspiracy idea go away? Because if they didn't do anything, it's just a thought in somebody's head, isn't it? If they can't prove anything was done off the back of it. But if he loses, he's stuck in expensive New York litigation. Discovery could expose his contracts, signal messages, PR strategy docs, his client list, and all the rest of it that he's still fighting not to have to reveal. So that's it, really. So this is what it tells you, how to spin this for YouTube. But that's it. That's more or less it. So I just wanted to give you that piece because I thought sometimes it's easy just to get a little breakdown because it gets hard reading the court docs when it's all the you get all the citations in the middle of it. It breaks up the flow of me reading it to you. But yeah, that's it. That's the Jed thing up to date. But yeah, it was highly amusing to have that pop in last night. And I just think it was such a clever idea to drop in the Taylor lyrics. And it just shows you as well how Blake shot herself in the foot by relying on that Instagram post where she quotes NY lady, as if that's going to make a difference because that had to mean that Jed knew she was in New York. It shows you how in real life, when you go down these rabbit holes where you're chasing arguments that don't need to happen and you're letting your ego get out of control and you're listening to all the yes men around you and all the rest of it, you will shoot yourself in the foot. And everything that you do, that you present as an argument, can be used against you. It's like, well, people will go and look for the minutiae of what can be extracted from that and use it to turn it against you. And it was quite a simple fix in that terms, wasn't it? It couldn't have been a more accurate flip when the actual lyrics say LA lady as opposed to NY lady. Nobody on Blake's team before that argument was composed thought we better go look at those lyrics and see what they actually refer to. That's kind of what we see with Blake's side. It's almost like they're the grandpas that don't know anything about social media or Easter eggs and subcurrents and social media and the rest of it. So when they're desperately cobbling together these arguments and using ridiculous things like how an Instagram post infers that you knew certain things, they don't think maybe we better unpick that and make sure that an argument against that cannot be created. And if they'd looked into that quote and that lyric, they would have seen that actually the real lyric is LA lady, and somebody can use a little bit of clever language and spin that against us, and it's gonna like totally humiliate our argument. And her side are just not doing that. They're not like being social media savvy about it at all, and they're not speaking to your everyday person who's following this, and they don't really see. I don't know. It's just an interesting disparity between the two sides, isn't it? But I just love the idea of this that kindly looking Charles Babcock with a very official sounding name, and coming up with the motion with the or the letter with the Taylor Swift lyrics and the tiny dancer correction and the rest of it. And yeah, I just found it entirely amusing last night. And yeah, we need a bit of levity every now and then. All right. So thank you for watching. Please do hit that like and subscribe and share if you can. If you can figure out on your device how to hype the video, apparently you can do that somehow from the comments. Kirsty says you swipe left or something. I am not managing to fathom it for myself just yet, but it may be that my videos might not yet be able to have that done for them. But if you do figure out how to hype them, please do hype them if you can. Help me grow a little bit. But I appreciate you all being here. Drop me a comment and I will try and get back to you and let me know what you thought of it all. And I will see you later.